To begin with, we are Caucus, the discussion forum of Hindu College. We are a 16-year-old non-partisan think tank, opines on a plethora of issues, including law. And The Probe is a magazine started by students of Caucus back in 2020 to garner a writing culture. And we have had students and experts across the world who have written for us and be featured on with us. So it's a great privilege for us to have you today as well. So
Thank
for our viewers and readers, today with us we have Senior Advocate Vikas Pahwa, and I don't think he needs any introduction. One of the finest lawyers of our country. So once again, thank you so much, sir, on behalf of the team for your time. And to begin with the questions, I would like to start by asking: you have been at the forefront of the legal domain for over 3 decades, participating in numerous landmark cases. To begin, I would like to ask you for your insights on how criminal jurisprudence has evolved in India since you began practicing, and what level of turbulence do you expect in the near future owing to the introduction of the Bharatiya series of criminal laws?
Thank you. Thank you for having me over. It's a pleasure to participate in this discussion. Of course, I've spent nearly about close to 31 years now doing criminal law in India. And although criminal law was not part of my first choice, since my father is a criminal lawyer and my grandfather was a criminal lawyer in Lahore High Court, so I picked up criminal law and I've been seeing, what happens in our society when I was very, very young. So when we started, it was somewhere in 92, 93, when I joined my father in Meerut. And Meerut is one place where, of course, it was the crime rate was really high. So there were a number of cases which we could see. I've seen a great change in the jurisprudence which has developed in the last about 30 years. And particularly the constitutional right of Article 21, right to life and liberty. I have seen how it has grown, how Supreme Court has given numerous judgments which help the accused in the court. Like some landmark judgments are like Arnesh Kumar's judgment on Section 41 and 41A was a game changer as far as the criminal jurisprudence is concerned. Then Satyendra Kumar Antil, which was recently, pronounced by the Honorable Supreme Court on bail, that's also a game changer. I've seen in UP particularly, even when the accused was not arrested during the course of investigation and charge sheet was filed, without arrest, still the judge used to take the accused into custody. So that portion of jurisprudence, that Section 88 of Code of Criminal Procedure, although was very, very clear, but no court was following it. So the Honorable Supreme Court in Satyendra Kumar Antil gave that judgment, and now almost across the board, the entire country follows Section 88, and the accused is not taken into custody. Lalita Kumari's judgment is a great change. When there was a direction that if the complaint discloses cognizable offence, then the FIR should be registered. Tufan Singh's judgment on confession, whether it is admissible in law or not, is also a great judgment. Judgment on anticipatory bail, on additional accused under 3 and 19. I have seen how the law has developed in the last about 30 years. This is, of course, pertaining to the judgments which are given by Supreme Court. I have also seen how new statutes were developed in the last about 3 decades. Money laundering, for instance, has now taken over any other statute. Most of the time we spent, in our offices reading that act and how to implement and how to challenge certain provisions. So our major time nowadays is spent in understanding and defending, and then also dealing with this act. And Information Technology Act came in 2000. It brought so many changes in the other statutes also. And POCSO came with regard to children, Prevention of Children Against Sexual Offences Act. About women's safety in the workplace, the act had come around, I think, in late 90s. So these are all, developments which have happened. Major development which I have seen is also introduction of technology in the last about 30 years. I have never seen technology taking over the entire criminal law profession. And so major change, major development which has happened in 30 years. And I've seen a lot. I remember when my father used to tell me, why don't you find a judgment on a particular provision of law? We used to, pick up a book from the library. We used to pick up a book, say yearly digest, and then go to the word index, then start, searching for a judgment. Today, all judgments are available on Google. You don't need to go anything anywhere, beyond that. So open your phone, look for a judgment, and you get a judgment. So that way, criminal law jurisprudence as well as the working of the courts have, improved in the last about 30 years.
Thank you, sir, for mentioning the journey of criminal jurisprudence. I'm sure we're going ahead, we'll be discussing many of those judgments and the interplay of criminal jurisprudence and technology. But for now, let's restrict ourselves to the criminal laws that have been enforced since the July 1st. The newly enacted criminal laws were passed by the parliament in the winter session, during which more than 146 MPs were suspended. This, coupled with scathing allegations of little to no transparency of the five-member committee, out of which only one member was a practicing lawyer, set up to draft these laws, begs the opinion that the deliberation of something as intrinsic as criminal law should have invited much more participation from relevant stakeholders like bar associations, jurists, etc., which did not take place. With that in mind, do you believe that is there any presumption to constitutionality behind these laws?
Well, I think the laws were passed by the parliament, so I don't think there's any challenge to the constitutionality, because presumption of constitutionality is inherent in all the statutes which are passed by the parliament. And of course, the way they were passed, it certainly raises some eyebrows, and people are asking questions about whether there was a widespread discussion among the legal experts or not, and how the bills were tabled and then ultimately passed. But as far as constitutionality is concerned, I don't think there's any problem, because there is a presumption in favor of the statutes. Yes, if we see all the three laws as a whole, then there are certain provisions which probably will have to be tested by the courts. So there's a judicial scrutiny which will happen in the near future. And also, the constitutional challenges will happen of certain provisions. But once the laws are passed, and they're passed by the parliament, right or wrong, they are the laws now. So we have to now look into them. We have to apply them. And in spite of all the uproar and all the opposition, the laws are there from 1st of July. So individually, I feel the provision may be tested in the court of law, both in the High Court as well as Supreme Court. In case the constitutional validity is being challenged, then it has to go to the Supreme Court. So I think a lot has to be done by the courts now. But yes, we have to see how these acts are implemented. So implementation becomes very important. The implementation has to be in the right perspective. Should not be misused.
Thank you, sir. You have mentioned that there are certain provisions which will have to be tested in the court of law on the basis of fundamental rights. According to some commentators, some of these laws, according to some commentators, the Parliament has disregarded the Supreme Court's decisions which state the seditions law on the grounds that these laws have no place in a democracy. In Sorry, sir, may I continue?
Yes, please.
One such law is Section 152 of BNS or Bharatiya Nyaya Sanhita. Sedition has now been brought back with sharper fangs, with grave words such as sovereignty or unity and integrity of India, as well as judicially undefined words such as subversive activities. Moreover, Section 197, Subclause 1, Clause D of BNS provides punishment for false or misleading information. How do you see these vague words affecting our current legal scenario, keeping in mind that these will not be implemented by special investigating agencies, but by regular law enforcement, especially after Apex Court's past holdings that vague words will create a chilling effect and will be anathema to the free speech?
Yeah, you're right. Actually, sedition is one law which has been grossly misused in our country, not only by the current government, even in the past. We have seen there are so many instances. That is why, on many occasions, the constitutional validity has been challenged. And although it was upheld by the Honorable Supreme Court, but then yes, of course, the law was settled, Here again, in the new act, the sedition law has come. Of course, it has come with more rigor, and it is more comprehensive. And I agree with you that there are certain terms which have not been explained. In the sense, the word like subversive activities. Now, subversive activities normally are activities where somebody challenges a government which is elected by the people. So you tend to challenge it and you tend to thwart it. So that is what subversive activities. But subversive activity is not defined anywhere. So once the definitions of any provision of law is vague, then it is open to misuse. Here, of course, I feel that this definition again will be challenged and will have to stand the scrutiny of the Honorable Supreme Court. I feel we require some kind of a guideline in which this sedition law can be applied. As of now, we feel that the definition is such which is prone to misuse. So, of course, on many occasions, the new acts have aligned itself with the Supreme Court judgments. But in this case, of course, as far as sedition is concerned, I think they have not aligned with the Supreme Court judgment. So this, of course, will be challenged according to me and will have to stand the scrutiny of the Constitutional Court in India.
Right. So thank you so much. But as you've already mentioned about misuse of laws, and one key thing which I mentioned, which I saw while preparing for the interview and while reading in general, is the nexus of the new laws with old ones. So preventive detention has been a key topic over the past decade in Indian criminal jurisprudence, with the BNSS now allowing for custody up to 90 days. How do you think the bail jurisprudence in India is going to evolve? And furthermore, how do you see the adjudication of the overlap between preventive detention and judicial custody under the new criminal laws and pre-existing laws such as the PMLA and the UAPA?
Well, of course, you're right. There is a change in the law with regard to police custody, but there is a lack of understanding among the general public that the police custody remand period remains the same. It is still 15 days. It's not 90 days. It's still 15 days, but that 15 days period has been extended to the extent that you can use this 15-day period in installments, in different periods. And the outer limit of the period is 40 and 60 days. Earlier, 15-day police custody remand was supposed to happen only in the first 15 days. So when an accused is arrested and brought before the court, then the period of remand starts. And by the end of 15 days, the option of sending the accused to police custody was not there. It was over. Today, according to the new act, BNSS, according to new BNSS, the 15-day period can be extended up to 60 or 90 days, dividing into various intervals. So, of course, that was not there earlier, but probably the only thought behind this is that sometimes the accused who's arrested is not in a position to be taken into police custody. In a recent Supreme Court judgment in Senthil Balaji, the accused who was arrested was in the hospital for 15 days. So police could not, conduct proper investigation. No custodial interrogation could happen. Therefore, the Honorable Supreme Court, while dealing with that bail, made a mention that why don't we now go beyond 15 days? And if accused is not available for the first 15 days, why not in the next 15 days, the police custody can be given? So taking clue from that, I think the new law has been amended, and now the period of 15 days can be spread to the first 40 days, depending upon the gravity of the offense, and then 90 days if it is much more serious. As far as UAPA and PMLA is concerned, these two acts have embargo on bail. So there are twin conditions which have to be complied with. And there are the two conditions are: first is that the prosecutor has to be heard, which is absolutely no problem. They can be heard in every case. Second is that while granting bail, the court has to give an opinion that the accused is not guilty of an offense. So therefore, the threshold is very, very high. Therefore, nowadays, in PMLA and UAPA, bail becomes virtually impossible. But again, the law is developing, the jurisprudence of bail is growing, And the Honorable Supreme Court, time and again, pass orders where they bring in Article 21, into these bail provisions. As recent as about 4 days back, Justice Suryakant has granted bail in a money laundering case purely on the ground that the accused has spent more than 1 year in jail and the trial is not proceeding, without complying with the twin conditions. So the Honorable Supreme Court says that sometimes you have to relax those conditions because you can't keep somebody behind bars for an indefinite period of time. And similarly, there is a proviso in both UAPA and the Money Laundering Act where, if there is a minor or there is a sick and infirm person or a lady, or in PMLA, there's a provision that if the proceeds of crime is less than 1 crore, then the bail should be granted. But these are very, very stringent provisions. And, looking into what is happening nowadays, we have to fight daily to get bails in the court, and the bails are becoming very, very difficult. So, bail jurisprudence also has undergone a change. Unlike what Justice Krishna Iyer has held in 1977, that bail is a rule and jail, uh, so, uh, and jail is an exception. Now it is just the other way around. The investigating agencies arrest and put people behind bars, and then we, from the defense side, have to say that we are not guilty of an offense. So I think bail jurisprudence needs to grow a little bit, and it has deteriorated in the last about 30, 40 years.
So thank you so much for that. So two observations which I want to share is that first of all, on the police custody part, it's
Yeah.
nice to have your opinion as well, your insight on it rather, because a lot of times we as regular people can't really get into the intricates and understand what actually these words mean. So it's wonderful to have you explain them. That's why we love having experts on the probe as well. And second was were your comments on bail jurisprudence, especially after judgments like Zahur Shah Vatali and Gurvinder Singh versus State of Punjab. So continuing on the same front, so Section 113 of the BNS procures the definition of terrorism from UAPA 1967 verbatim, further exacerbated by removal of certain safeguards in the said act. With that in mind, I have two questions. First, why do you think there was a need to form a general law for the same crime for which a person can be convicted in the special law? Is this the normalization of special laws? And secondly, how do you see this panning out in the field, given that we've already had allegations of the misutilization of the UAP?
You see, as far as terrorism is concerned, if you go in the past, you will see in 1985 we had Terrorist and Disruptive Activities Act, which was valid for 10 years, say from 85 to 95. And then we have POTA, Prevention of Terrorism Act, that also lived its life. Then the terrorism law was brought into UAPA, and that is what at present, the terrorist activity can be punished under UAPA at the moment. It's quite surprising even for a lawyer like us that why in general law we have a definition of terrorism when we already have a special law dealing with it, and we have special investigating agencies dealing with it. So UAPA, if you see, has a schedule as to what are the activities which can be investigated. Most of the time, UAP is investigated by NIA, which is a specialized investigating agency. But bringing terrorism into general law was quite perplexing even for us, because we understand the complexity when there is a general and special law with regard to same act. So there's always, it's an overlapping effect. So very often we will see the problem when an activity like this happens, and whether it should be prosecuted in general law or a special law. General law means local police of that area, and special law means investigating agencies like NIA. I don't understand the need. Where was the need? I feel the government might be feeling that let's bring it in the general act, because the special act will die its own death gradually, and then we will have only the general law. But that's a very dangerous proposition, because it has an impact of having conflict with the local police and the specialized investigating agency. Suppose in a terrorist activity, the FIR is registered by a local police, so, and they have every right to do it. But then after some time, the state government or the central government feels that they are not conducting the investigation properly, they'll try to transfer it to a specialized agency. So then that creates a problem. That creates a blot on the acumen of the investigating agency, like a state investigating agency, when you yourself have given them the power to investigate. So there, I feel there is a conflict which could have been avoided, but I have not seen the parliamentary debates as to why this definition was brought into the normal law. Maybe there is a reason, but I don't see any viable reason to have a special activity. Special activities, special statutes are created for special activities. Just like money laundering is a special act, negotiable instrument act is a special law. Otherwise, even for dishonor of check, people were filing cases under 420, saying that you have given me a check has been dishonored, so I have been cheated. So special statutes are created for a class of offences. So in this case, UAPA was already there. I don't think there was any need, but somehow, since it's there, so we have to see how it progresses. And of course, there has to be a judicial scrutiny of each and every case which will be filed in these provisions. But there'll be an overlapping, and there'll be some chaos in this. I also expect in future there'll be some chaos with regard to this particular definition.
Thank you, sir. What I could infer from your answer is the arbitrariness of the police that will be enhanced by the introduction of these new laws. Now, talking about the arbitrariness of police, Section 173, Clause 3 of the BNSS requires the police to conduct a 14-day preliminary inquiry before an FIR is ever registered for offences with punishment between 3 and 7 years. This takes us back to the pre-Lalita Kumari era of 2014, wherein the police had carte blanche power to register FIRs, which saw widespread discrimination on basis of caste, class, etc. I would like to ask you, when there is a well settled law that only for a certain dispute, such as marriage or civil, you require a preliminary inquiry, do you think that there was a need to reintroduce or rather reshape an existing jurisprudence? More importantly, what are the effects that you will foresee that will happen to those people who the police will deny the FIR?
This preliminary inquiry is only in limited number of cases, only in offences which are punishable up to 3 or maybe 7 years. It's not in all the cases that preliminary inquiry will be conducted. I have always found that preliminary inquiry helps in the investigation, and it helps in delivery of justice. That is my view right from the beginning. Even in Lalita Kumari, there was a provision of preliminary inquiry in certain category of offences like commercial dispute, matrimonial dispute, and where some bureaucrat is involved. There is a I think in para 120, somewhere in the middle, E or F, there is an exception which has been given even in Lalita Kumari. So preliminary inquiry means before you register the case, you call the other side, conduct an inquiry, and tell them to give their version so that you have both the versions in front of you, and then you decide how to deal with the matter. So preliminary inquiry is only for the purposes of ascertaining whether an offense is made out or not. And BNSS says it should be only for 14 days. So maximum period is given. It's not that it is going to be for an indefinite period of time. It will be only for 15 days to ascertain whether an offense is made out or not, to collect material from the other side, to give to accept a representation or a version from the other side, so that you have both the versions, and then you decide how to go about it. But see the anomaly. If Lalita Kumari prevails, then even a false complaint can be registered. So when a false complaint is registered, after that the investigation starts. Once the investigation starts, by that time the crime is registered and the CRPC comes into play. Then you have to decide whether you have to arrest the accused or not. Once you register, there's an automatic movement of the file in terms of CRPC. So, but if you are doing preliminary inquiry, it is very informal. It is not structured. But once you conduct an independent inquiry, you can hand over a file to a senior officer by saying that, look, I have called the other side, I have got the version of the other side, this is the material evidence which is exculpatory and inculpatory, both are given to a senior officer, and a decision is taken. So I think this aspect of preliminary inquiry under section 173(3) is a welcome change according to me, and it will have a positive impact on the justice delivery system.
Thank you, sir. Talking about the positive changes that have been brought forth by these newly enacted laws, There are various positive aspects such as community service, videography, forensic scientists,
Yes.
trial in absentia. Sorry, sir?
Yes. I can. Please go ahead.
Trial in absentia, zero FIRs, timelines for the processes, etc. How do you see these being implemented in the field?
Well, a community service is a welcome change, but it's applicable only in very limited number of cases, very minor offenses. I think in only about out of many hundred, only 7 offenses where community service is prescribed. Very minor offenses like defamation is one. Defamation is good. That in the case of defamation, community service has been introduced. But see, a minor offense where a public servant is found to be involved in some trading is an offense, and if a person doesn't appear before the court, he becomes proclaimed offender. There, community service is an option. In a case of theft, also, community service is an option. So it's a welcome change, but of course, community service should have been defined. It is not defined anywhere, so we don't know. Every judge will apply his own mind and pass an order with regard to community service. I remember a long time back in one of the courts, the judge in a traffic violation case. So he told the accused, I think it's a case of rash and negligent driving. He told the accused to stand in the middle of the road and see how the traffic passes and help the traffic police. So all those kind of community services. So since it is not defined, so it'll be very radical, and every judge will apply his own mind and pass the requisite orders. With regard to videography, I feel that's a welcome change, because if you see, there are two definitions which have been introduced in BNSS. One is audio video electronic, and second is electronic communication. These are two definitions which have been introduced. So audio video electronic means anything which is recorded by video can be produced in the court as evidence. So the search and seizure, which is normally conducted, that has to be now videographed, right? The examination of the witnesses under 161, the confessions of an accused, all those can be video recorded now and can be produced in the court. And the recoveries which are made can be video recorded and given to the court. The trial court proceedings can be conducted by video recording. So I think introduction of audio video is a game changer as far as I'm concerned. I feel that will change the entire perspective of the criminal justice system in our country. It will expedite the trials. I remember going to Greece, I think 2017 or 18, and I did a trial in Greece where the entire trial was conducted through audio video electronic mode. Like, when we call a witness in the court and we start recording the statement, we type it. Earlier, it used to be typewriter. Now we have computers. So we ask the name of the witness. He gives the name. He gives his father's name. It's recorded. Then a question is asked. Then the question is typed. Answer is given. Then answer is typed. This is the way we record the witnesses in the court. That's why it takes such a long period of time. In Greece, there was no typewriters. There were no computers. Everything was digitally recorded. So the witness had a mic. All the judges on the dais, they had a mic. The prosecutors, the lawyers, everybody had a mic. And whatever they were talking was being digitally recorded. So I could see in one single day, more than 15 or maybe 20 witnesses were recorded. In our case, in one single matter, in one single trial, 20 witnesses means maybe a few years. Maybe 1 year in case we have a special court, or maybe 5 years in case it is not a special court, because of the fact that our system is very slow. But if we audio and video record entire proceeding, then it will be recorded just like you and I are talking. If I am cross-examining a witness, I will ask question, he will answer, I will ask again, he will answer again. So it will be like a communication. So that really helps. So I think this videography and audio, which has been introduced in BNSS, according to me, is a game changer. That will have a great impact on the speedy trials. Then you are saying forensic science. Forensic science, of course, in any case, we were using it. But now the reports which are given by the laboratories will be accepted as it is. In case somebody challenges it, only then you have to call an expert for cross-examination. Now the provision is you accept the report, it will be accepted. There's a presumption in favor of that report. So that is also a good change. And then you said trial in absentia. Trial in absentia again is a great concept. There are so many trials in our country which are not happening because the accused is not available. One is he's not available. Second is he doesn't want to come because he can't come because of logistical reasons. So today, since the appearance of the accused is accepted through technology, even those trials can start, where the accused is outside India or is available only online. So he can appear online, he can cross examination online, and he can conduct the proceedings online. And in case he's absconding, then of course, in his absence, the trial can happen. This trial in Greece, which I'm talking about, is a trial where the accused was in India and trial happened in Greece. So there, of course, it was a trial in absentia. There, the Greek court accepted it, and the parliament over there passed a law that you can have a trial in absentia. So therefore, we could conduct a trial, and we win the appeal in the High Court as well as the Supreme Court in absentia. So that I think is a great change. And then zero FIR, as you mentioned, zero FIR also is a game changer. People used to fight for registration of FIR. Now the FIRs can be registered. The only flip side is that we don't want the non-jurisdictional police to conduct investigation in those zero FIRs. Suppose crime has happened in Delhi, FIR registered in Bombay. Then Bombay police should immediately transfer the case to Delhi. But there is some lacuna in the provision. I was reading the powers of investigation where they have introduced the word, even if the court doesn't have jurisdiction. That means you are giving right to Bombay police to conduct investigation in a case which has happened in Delhi. That should not happen. Zero FIR means only registration and then you transfer to the court which has jurisdiction. And timelines, I think you have also mentioned about timeline. Timeline also, according to me, is a game changer. Today, on an average, the trial which is happening in our country takes years. Minimum 5 years, it may take 10 years, it may take 15 years also. Even Honorable Chief Justice, I think yesterday made a statement in one of his speeches that people are going for settlement because, they get frustrated because of the delays and because of the fact that the trials are taking so long. But now we have a timeline. We have a timeline of supply of documents, which is around 21 days. Then we have a timeline for the committal of case to a court of sessions, say about 90 days. Then we have 60 days for filing an application for discharge, 60 days for deciding the application for discharge and framing charge. Then we have a trial, which is through digital technology, which of course will get expedited. Then we have a time for judgment within 30 days, and at the most 45 days, you can give the verdict, the judgment. So I was just calculating, if we calculate the number of days for investigation and we calculate the period of the trial, which is through technology, we have 276 days additional. So we have investigation, 276 days, and then we have the period of trial. So roughly around 9 to 10 months. If we follow the timeline given in BNSS, the trial can be over in less than 1 year now.
Thank you so much, sir, for that answer, especially considering how many aspects you have answered in that
Yes.
one question. So, but one thing that I noticed from your answer was the emphasis on technology. Now, we all know everything has a flip side as well, and we have major technological firms like the Internet Freedom Foundation also pointing out certain issues with law and technology. So, I would like to ask a question. How do you see the interplay of technology and the internet with these new laws? Moreover, due to the ever growing reach of the internet, how do you see allegations such as defamation, or online defamation, and other things playing out in the criminal landscape governed by these newly enacted laws? And do you think that these laws serve enough to secure the privacy of an individual as guaranteed in the last decade?
Yeah, of course, technology has its own flip side. So the biggest problem in a case like defamation would be the jurisdiction. I make a statement in Delhi, it goes all over the world. So person who is staying, the law on defamation is that whoever is defamed at a particular place, suppose somebody says anything about me and my friend sitting in Bombay says that I heard about that statement and I feel you were defamed, then Bombay courts will have jurisdiction. So wherever a person is defamed, so when you talk about technology, then you talk about world as one. Somebody sitting in England may say something about me, and I get defamed here because of the technology, because of the internet. So jurisdictional issue will be a big challenge as far as the defamation is concerned. And of course, with introduction of technology and internet, the biggest problem would be the data, preservation. We are talking about the entire criminal justice system taken over by the technology, but how do we know? How do we protect all this? We don't have the infrastructure at the moment. So we have provision in CRPC which says that the police officer who goes on the spot when the crime takes place, he has to record the crime scene on his mobile. So it's okay when we are in Delhi or in Bombay or in on any of these towns. When we go to the rural areas, how many head constables or sub inspectors have the technology with them? How many of them will be able to record the crime on the phone? And then the requirement is that the investigating officer will send the recording to the executive magistrate immediately thereafter, because we have to maintain the chain of custody of that evidence. Then how do we know whether the executive magistrate has the technology available with him or not, whether he has the infrastructure available with him or not? Then magistrate will store it somewhere, whether we have any storage facility or not. Then it goes to a courtroom, whether the court has digital technology or not. So the biggest problem which we will face today will be the infrastructure issue. I don't think, except for the metropolitan, even in mid-sized town, I have not seen technology being used. The judges are very reluctant. If we make a request to any mid-sized town place and we make a request for appearance through VC, so the judges are very, very reluctant. Of course, in big cities we have that facility. So biggest problem with introduction of technology in the criminal justice system would be the infrastructure. So the government now will have to invest more money in upgrading the technology. And as far as defamation is concerned, I personally feel defamation should be decriminalized. It is grossly misused. And I have done few cases. If I've done 10 cases, for instance, 8 of them were politically motivated. So I have not seen any genuine defamation case which happens in the court of law. So the law of defamation is being used for your political purposes. So it should be decriminalized, is what my personal view is.
Thank you, sir. Having talked about the legal and the technological issues associated with these newly implemented criminal laws, I would now focus towards the social issues. Do you think that these laws have served well the growing demand of gender justice? Keeping in mind that the Section 377 of the erstwhile IPC is not recognized in the BNS. Furthermore, what would you categorize as the best reform that has been brought forth by these new laws?
I think yes, 377 in any case was decriminalized by the Honorable Supreme Court. So it's good to see that the new acts have aligned with the judgment of the Supreme Court. As far as 377 is concerned, it is not a crime anymore, because this is one offense which was grossly misused, and not because of the genuine 377 cases, but even a lot of false implications were happening. People started using 377 in matrimonial disputes, which was so depressing for a criminal lawyer like me to see that how the society was getting affected by misuse of Section 377. And 377 now, since it is not there, so I feel it is much better. So the government is aligned with the Supreme Court judgment. And now, second question. What was the second question?
What would you categorize the best reform that has been brought forth by the new laws?
The new laws. Yeah,
Yes, sir.
the best reform, of course, technology, I've already told you, which is a game changer. Timeline is something totally different, which also is a game changer, which is a new thing. And among the reforms, the offenses are more or less the same. If you see, BNS per se has not changed much. It's the procedure which has undergone a change. So according to me, technology and timeline are two aspects in the new laws which will have a great impact. But there are some provision I can just tell you which I feel may create a problem and may be misused. One is section 105 of BNSS. 105 BNSS is the power of a police to attach the property. We have in Money Laundering Act, the Enforcement Directorate has a right to attach the property, but that attachment is subject to being endorsed by adjudicating authority, then by a tribunal, and then by the High Court. And then the property stays in attachment till the trial is not concluded. But here you see, I don't know how it has been worded. In 105, in any offense which is mentioned in BNS, the property of an accused, which is proceeds of crime, can be attached. And holds whether the trial is concluded or not, the property can be given to the aggrieved party, or in alternative, the government can also appropriate it. So they will not wait for the trial to be over. Suppose the accused is acquitted, then what happens to the property? Property has to be given to an accused. But this attachment under 105 is not subject to the outcome of the trial. That is one thing which I feel can be misused. Among good things, I don't know, you can ask me, I can respond, but often I don't remember any major, reformatory, some provision except community service. You have already asked me. Yes, you have anything in your mind, you can ask me. I'll tell you whether it's appropriate or not.
So, sir, we are now at the second last question. Taking that bad things, or rather, quote unquote bad things, Section 43, subclause 3 of the BNS now gives the police wide powers to handcuff anybody.
Yes.
Keeping in mind that power to handcuff has been widely criticized by the then great Justice V.R. Krishna Iyer. In light of these events, how do you see these wide powers?
I think it's going to be grossly misused. Handcuffing was severely criticized by Justice Krishna Iyer, I think, in 1980. 1980, he gave a judgment that there should not be any handcuffing unless and until it's a very serious offense, or you apprehend some violence, or you apprehend that the person will abscond, unless you have those exceptional circumstances. The handcuffing is something, which just imagine a situation where there's a fight between two neighbors. One of them is more powerful, he has an access to the cops. So he, just to satisfy his ego, just to defame the other person, just to make him feel bad, he can tie up with the cops and will make sure that he's handcuffed in his house, and then he's paraded on the road. So this kind of power should not be given to the police at all. It will only give rise to corruption. That, the influence of police will be used to handcuff and to make sure that he feels he's degraded and all that. So this power, in my personal view, should not have been brought at all. Handcuffing was it was only an archaic, provision which was there earlier. And since 1980, there was nobody was being handcuffed unless and until, a person is a terrorist. The cops were called, and they have to intertwine their hands, and this is the way an accused is brought to the court. But handcuffing, in my view, also will be grossly misused. I think it will be challenged for sure, and will be set aside.
So thank you so much, sir. So far, it's been thoroughly engrossing to listen to you, especially with so many unique insights you brought so far on things we wouldn't get to know about without having experts like you. So just to conclude now, the legacy of the previous laws cannot be summed up in such a short conversation that we are having. But to look to the future, I would like to ask you what expectations you have for the future of the criminal jurisprudence in the country with regard to these new laws, and how do you think the practice of law is also going to evolve in the foreseeable future?
Well, I think these laws, if they are adhered properly, if they are implemented in the right perspective, if the law enforcement agencies are educated well on these laws, and the overreach is checked by the judiciary, and the public at large are also, there should be law literacy. We have to educate them about the laws. If people are not aware of their rights, how will they enforce, or how will they invoke in the court? So I think if it is implemented in the right perspective, then it can be a game changer. I certainly feel this timeline, technology, and the other provisions of law which have been short circuited. Like one big change is that in summon cases we always used to challenge a summon in a higher court, but there was a law in 1982 which gave an opportunity to an accused to go to the same court and say, sorry, you have issued the summon wrongly, these are the facts of the case, kindly recall. So that judgment was overruled by Supreme Court. So by way of a provision, by way of an amendment, now that power has been brought in, that a magistrate who has issued someone can also withdraw it, discharge an accused. So the multiplicity of litigation has been ruled out. So you go to the same court, you plead before the same court, and you can make sure that the case is over there rather than multiplying and taken to the higher courts. So there are some good provisions. There are some provisions which needs to be relooked, and some, of course, where there is a judicial scrutiny which is waiting, according to me, and some constitutional challenges which are pending, which will be there for sure. So I feel, but if we go with a positive frame of mind and we use technology and we make sure that people get timely justice, swift justice, as they say, then I'll be quite happy to see that. But as on date, the real punishment of an accused is not in the sentence which he gets, but in the process of trial. But the trial itself is taking years. Sometimes it has taken decades. We have examples where in 30-40 years the trials are not over. In Augusta Westland case, which is so famous, of 2014, the ECIR is of 2014 in a money laundering case. We are in 2024, even charges have not been framed. So we have not reached the stage where the trial is about to start. So therefore, these are all examples where we have to learn, and we have to make sure that it should not become a tool of oppression. Filing of a case, arresting people, and then having stringent bail provisions, making sure that people don't even come out of jail for a substantial period of time. That needs to be curbed. One more. I just remember one additional provision in 436A, the erstwhile 436A. There was a provision that if a person undergoes 50% of sentence, then he will be released on bail. Now that 50% has been reduced to 1/3, which is a good sign, because in many cases we see people are languishing in jail for years. So 1/3 means in a case of 7 years, maybe 2 years and few months, roughly around 2 years, he will be able to get bail if his trial is not started. If he has not been granted bail earlier on merits, he can get bail purely on that provision of law. That is also a good change in the new law. So we have a very it's a modern looking act, which I feel should have a positive impact on the trial. Some people are saying that these acts were futile, the acts would have been amended. If you see I have just noted down, I don't know how many uh, amendments are there. If you see the provision of law, earlier in CRPC there were 484 sections, now we have 541. So there's an introduction of about 60-70 provisions. We have 177 amendments which have happened in the new. Amendment means the new provisions which have been introduced in the old. And then we have 9 new sections, we have 39 new subsections, and there are 14 which have been deleted. So massive amendment has taken place. So the government, in its own wisdom, thought that instead of amending the statutes, let's bring a new law, which is all right. So it's like an old wine in new bottle with some new changes. So I in fact personally welcome it. I feel since the laws are implemented, now we have to deal with it. So why not we deal with it in the right perspective?
So it's been a pleasure to speak to you, and thank you so much for your time.